Hi, everybody. Letting folks in from the waiting room now, so just give us a couple of moments and we'll be getting started. Okay. So thanks for coming. Today's webinar is about protection orders, domestic violence restraining and no contact orders in Washington State. Michelle Dellino is going to join us here in just a moment, and we're going to be getting into the nitty-gritty about various protection orders. And I just want to quickly introduce myself. My name is Melissa Rosenberg, and I'm actually a therapist here in Seattle, Washington. One of my specialty areas is working with clients who are navigating different stages of the divorce and separation process, and also just dealing with complex relationship issues in general. And quite a number of my clients have had challenges with domestic violence or other issues that have caused protection orders to need to be a part of their picture. And so today I'm actually here as the moderator for this webinar. And what we're going to do is Michelle's going to deliver a lot of great information about the different types of protection orders and what goes into all of that. And we'll be also here to take your questions. Two different ways that you can ask questions. You can ask them to me in the chat. If you ask them in the chat, that will only come to me and I will pitch them and we'll try to answer as many questions as we can. There's also a Q&A option on the Zoom screen. And if you click that, you can ask a question there too. That will populate your name on the screen with your question unless you choose to mark yourself as an anonymous attendee. So just a heads up on that. Either option of submitting questions is just fine. The only thing about questions, we want to answer as many of them as we can. We just can't get into really specific, case-specific information with a lot of detail about your specific situation. More general questions, we'll try to piece that out and do the best that we can to get as many things answered as we can. So happy Friday. Thanks for joining us today. And I'm going to hand it over to Michelle.
Hi, I'm Michelle Dellino. I'm the owner and founding attorney of Dellino Family Law Group. We have offices in Seattle and Bellevue, and we actually help clients all over Washington State. Today, I'm here to give you some information, and I should start by telling you I'm an attorney, but I'm not your attorney. And you watching this webinar should not take this as legal advice. This is information for you that I think will be helpful in you understanding the different types of orders that are out there, what they mean, what that's all about, and really what to expect and maybe what's appropriate for you. But if you have, like Melissa mentioned, if you have very fact-specific questions or need fact-specific information, you're going to want to talk to an attorney about your own individual situation. So you feel free to ask questions. We'll do our best to answer them. I'm going to go through and give you some general information and appreciate you being here. So with all of that said, let's start talking about protection orders, no contact orders, and even beyond that, the different types of protection orders that you can get. So protection orders are often things that come along as part of a family law case, and other times they are things that you might get if you don't even have a family law case. So if you're watching this webinar today, whether it's recorded or whether you're here live with us today, you may have a family law case that's a divorce, you may have a parentage action, you may not. You may just be dealing with a domestic violence situation. So when we talk about protection orders, it's important to acknowledge that they can be part of a lot of different contexts. It doesn't have to be a family law case. So we're going to talk about the difference between civil orders, which are protection orders, and we're going to talk about criminal no contact orders. We're going to talk about statutes and practical strategies and a lot of things you probably don't need to know. But I do want to tell you something in case you're somebody that likes to look things up. So in 2023, the Washington statute on domestic violence protection orders changed. And now the key statute is RCW 7.105. That is the Uniform Domestic Violence Protection Act in Washington. This used to be, and you don't need to know this, but some people do, so I want to clarify. This used to be under Title 26, where if you're looking up statutes that have to do with family law, everything is Title 26, which is domestic relations. Domestic violence used to be defined there. But with the changes in the law in 2023, now RCW 7.105, the Uniform DV Protection Act, is where you go to find out definitions and all of those things. RCW 10.99 deals with criminal no contact orders. You probably don't need to know that, but it's something to know. And then RCW 9A.46 defines harassment. So that's kind of the nuts and bolts on things that you might want to know. One thing people want to know is, what court do I go to get a protection order? So there's Superior Court and District Court, and there's municipal courts. These are all different kinds of courts, and it can be really confusing to know where to go. So we'll talk a little bit about that. The first thing I'm going to talk about are domestic violence protection orders. And now you might also hear these referred to as DVPO. So DVPO is a domestic violence protection order. And again, these are very common orders in Washington state, and the authority for them is in RCW 7.105, specifically subchapter .100 through .500 if you are a statute seeker. So definition of domestic violence, it has changed since over the years. For many years, it was a very limited definition, well, more limited than now, and it still does include physical harm, assault, sexual assault, stalking, or in Washington, it has included and still does the imminent threat of physical harm. So if a reasonable person would think that someone's doing something that's going to make them feel like there's a reasonable threat, and that very often is someone throws a dish or throws something, and maybe they don't throw it at you, but they throw it near you, and so you have a reason to think that you're going to be harmed. That's just an example. Someone does something or says something where a reasonable person in those circumstances would think that they were potentially going to be physically harmed, that would fall under the imminent harm part. But in 2023, the definition, in addition to that, includes coercive control. And coercive control is a large and important addition to the domestic violence statute. So we'll also talk about that. Who can file for a domestic violence protection order? Not anybody can. Domestic violence, you have to really establish what is the relationship. If you were intimate partners, current or former spouses, dating partners, family or household members, and certain vulnerable adults that might fall under the domestic violence portion of this, they can file for a domestic violence protection order. If you're just somebody that's never lived with you, never been in a relationship with you, has no family relationship to you, you're probably going to be looking for a different type of order. So domestic violence requires that relationship threshold. So what's the process of getting a domestic violence protection order, and should you do it yourself? That's a really big question. I will tell you that what you plead, which means what you put in your petition and declaration, is extremely important. So you can use help of a DV advocate to do that. You can do it yourself. I highly recommend, if you can, that you talk with an attorney, because we understand the statute and we understand what is considered domestic violence and what isn't, and the best way to position that to the court. You also cannot come back later and plead other things that you didn't know were domestic violence and didn't put them in your petition. You would need to amend your petition, or you might not be able to bring those things up. So what you put in that petition is extremely important. And the process is basically filing that petition with your declaration and any other evidence, having other parties served, and then having the hearing, and then the relief is granted. But there's a little more to that. When you file it, most of the time, people will step in and they will want to go to what's called ex parte, where they appear and they ask the court to issue an immediate order without notice to the other party. Ex parte means one party's going in, there's no notice to the other party. And then when the petition is served, there's a temporary automatic order that was just issued that they're getting served with. So otherwise, you'd be serving them, and then they have to wait 2 weeks for a return hearing. And during that time, if you're worried about domestic violence, that could be a really dangerous time for you. So this puts an immediate order in place. Is that always issued? No. Most of the time, if there is a reason to believe that domestic violence may have occurred, it is issued. So it really should start in most cases with going in and getting that ex parte order when you file the petition. And then law enforcement serves a domestic violence protection order petition. You or you don't. And civil process units generally don't either. It needs to be law enforcement. Sometimes there's a firearm surrender that goes along with that. And it's also just recognizing this is kind of a high risk situation, right? So you want to be sure that when you're having that served, law enforcement is serving that, and that's part of the process. There are family law intersections with domestic violence protection orders. You might hear, if you have a family law case, about 191 restrictions or supervised visits or any of those things. So when you hear 191 restrictions, that refers to RCW 2609, subsection 191, and that lays out restrictions in a parenting plan. One of them is domestic violence. And if there is a domestic violence finding, like in a protection order, that can be a basis in your parenting plan to restrict time with the other parent. So that's really important for you to know. So there are intersections with that. And so you want to understand, like, especially if someone is claiming that you committed DV, or if you are seeking a DV finding against someone else and you have a family law case, you want to understand that. So that's really important. Before I move on, Melissa, is there any questions you want me to take right now?
There are no questions right now, but I want to just quickly put in a plug that this is National Domestic Violence Awareness Month as
It
well. So
is.
this is a very poignant topic. And just a plug around ensuring that if this is something that's part of your life, you're adequately supported on an emotional level as well. Making sure that you have people in your life who are trustworthy, who you can um, rely on for support unconditionally, and that you're potentially seeking professional support from a mental health perspective as well, because domestic violence is very scary and it can take a lot of different forms. And feeling like you have the right types of support and ability to be safe, and within the arenas you're trying to access support are extremely important. So just putting a little plug.
Yeah, it's a really good point. This is Domestic Violence Month. That's part of why we're doing this month. And just, domestic violence doesn't get talked about enough. We go through phases, I think, where something happens in the media or people are talking about it. But in general, one thing I think that's important for people to know is that domestic violence touches everyone. It doesn't matter how much money you have, doesn't matter what neighborhood you live in, doesn't matter if you're married or unmarried. It can happen anywhere, and it is probably happening in places that you don't think or that you don't know. So it's very important for you to know that raising the awareness about domestic violence and even acknowledging, if you think it's happened to you, you want to talk to somebody and you want to get help. Because one thing about DV, the cycle of DV, that's very common, and we could do a whole webinar on the cycle of DV about someone committing DV, whatever that looks like, someone apologizing, that kind of behavior, and this cycle, and then the escalation of DV too, and how the types of abuse can escalate and can really put people at risk. So it's very important to acknowledge. So thank you, Melissa, for remembering this response. That's a very good point. I talked a little bit earlier about how if you don't fall into a pattern, a relationship threshold, or maybe the conduct isn't necessarily domestic violence, there's other protection orders. Another most common type of protection order are anti-harassment protection orders, or AHOs. The authority there is RCW 7.105 subsection 200 through subsection 260, where it defines and talks about harassment and anti-harassment orders. So what is harassment? It's basically harassment that doesn't constitute domestic violence. So it's not stalking. Maybe it's repeated contact. The definition really is who can get it is anybody that's subject to a course of conduct that seriously alarms, annoys, or harasses with no legitimate purpose. So let me explain that a little bit. If you're in a situation where someone is, and this happens a lot, unfortunately, in co-parenting relationships, someone is sending repeated emails under the guise of talking about a co-parenting situation, right? And I want to talk about this, I want to talk about that. But then at a certain point, there's really no point in saying anything else about it. And yet you continue making personal attacks. You've sent 50 emails today when, one could have sufficed. There's no legitimate purpose for the contact. So, sometimes there are patterns of harassment where there's a legitimate purpose. Hey, we're having a meaningful argument, you and your neighbor, about the fence line, right? And then maybe these are often anti-harassment orders can be neighbor issues. That's why I'm bringing this up, because it's a common fact pattern. And then somebody escalates that from beyond where, hey, we're having this contact to now like won't stay away, excessive communication, insults, and really escalating it. So there has to be a legitimate purpose for the contact. If there's not, and especially if you've been told to stop, then you're treading into that, am I harassing or am I being harassed category. The distinctions between this and a domestic violence protection order really are that there's no domestic relationship required, and the relief options are narrower too, as far as what you can do. The common context one I just said is neighbor, workplace, or social media harassment can also be a real thing. So anti-harassment orders are not uncommon, and they often fall into those neighbor or workplace type people disputes, or somebody that maybe is only harassing you electronically. That's also a very real thing and did not used to be such a thing. So those are very common. Other types of protection orders include sexual assault protection orders. And this is really interesting. Well, maybe not interesting to you, but important for you to know. So the legislature has acted in recent years to make it easier for somebody that needs protection to get it and to not have to plead for necessarily the appropriate order. You can just plead for a protection order, and basically it can be determined which one is the right one for you. So sexual assault protection order is usually a protection order that you would get more if you have a situation where it's not like a dating relationship, because if you were in a dating relationship or a spouse relationship, you would be able to get a domestic violence protection order. But if this was a random sexual assault and you were sexually assaulted, and there's a whole definition for that, but it's pretty much what you might think it would be, and you're sexually assaulted in some way by someone that you don't have a relationship with, you can't get the DVPO, but you can still get what we call a SAPO, or a sexual assault protection order. It used to be that sometimes people would think, hey, I'm sexually assaulted, and it would be by a dating partner. They would plead for and try to get a sexual assault protection order, only to be told they can't get it, and they didn't understand why. And now and then they could be rejected for that or any number of things. So now it's like you're trying to get the relief. It's not really as important that you figure out which one it is. So that's good for somebody that's seeking the right kind of relief. An anti-harassment protection order as well. Sometimes you don't know, oh, I shouldn't be getting this protection order. I should really be getting an anti-harassment order. And so there's a little bit more flexibility in figuring that out now. Let's talk about no contact orders, because people will often say, hey, I need a no contact order. I want a no contact order. And they don't really know like exactly what that means. And my dog is barking, so bear with me for a moment as I put my AirPods in. All right. Sorry. So when we're talking about no contact orders are not issued. They're not issued by Superior Court. Okay. And that's very important for you to know. No contact order, well, they could be if it's part of a criminal case, but it's not an order that you're going to be able to walk down and get. You're not going to walk down and say, I want a no contact order. That doesn't happen. A no contact order is what I would call a companion order. It's a companion in a criminal case. So if you have a felony criminal case, that's in Superior Court. If you have a misdemeanor, that's either in district or municipal court. And so if you're the victim of a crime that's being charged, and let's say it's an assault or something like that, then the court will enter a no contact order while the case is pending, and in many cases afterwards, keeping the alleged perpetrator away from you. But the criminal court will issue that. You don't plead for it. You don't even have any control over it. A lot of the time, and I mention this because in the family law context, a lot of the time, there'll be some kind of a domestic issue at home. So here's a real world application of this. Somebody will get in a fight at home, and one spouse will get arrested for assault for DV, which is misdemeanor assault. I mean, that can even be I spit at you. It doesn't necessarily mean I beat you, but it could be I slapped you, I spit at you, I pushed you. It could be any of those things. And you could go and get a DVPO, but maybe you didn't. And maybe you and your spouse dealt with it and you didn't want any kind of intervention, but your spouse got arrested. So the court is going to issue that no contact order, probably even if you don't want it. And then you're going to have to ask the court, if you don't want it, to rescind it. But they're doing it because oftentimes victims of DV don't go get that protection order. They do fall into that cycle of violence. They do think, oh, this person's sorry, it won't happen again. So they're acting to protect you. Likewise, if you're an alleged perpetrator and a defendant and you've been arrested and there's a no contact order, do not violate it unless that order gets lifted. Work with your attorney to try to get it lifted. If you violate any of these orders, a DVPO, an anti-harassment order, a no contact order, a sexual assault protection order, a vulnerable adult protection order, which we haven't even talked about, if you violate any of those, it's a gross misdemeanor. It's a charge, and you're going to get charged with a crime. So if you have 4 violations, it's a felony, but otherwise it's a gross misdemeanor. And what that means is a gross misdemeanor is punishable by up to 365 days in jail and a $5,000 fine. So, and it's a pretty serious situation, especially if you also have a family law case going on and you violated this and you're like, it was a misunderstanding, I didn't know. It looks bad and you can be in a lot of trouble. So if there's an order in place, don't contact the other party even to be like, why'd you do this, or can we work it out? You need to go through counsel. If you even want to try to broach that subject. I can't tell you how many times somebody gets served, they're confused, they're like, what the heck's going on? They try to reach out to the other party and now they have another charge. So don't do that. I guess I would say don't let that happen, and just be very aware that if you get served with an order, it's paramount that you understand what that order is, and that there's all these different types of orders going around, but they all have the same common thread, which is don't violate them, and get clarity from an attorney before you do anything. So that I can't stress that enough for you. I I was going to talk about some kind of considerations on when to get these orders and so on and so forth. But Melissa, I wanted to ask you, um, if you have clients and they come to you and they're not sure, should I get a protection order or not? I mean, just on like because a lot of clients come to us and they're really struggling, like, should I do this? Is this going to make me feel bad for the other party or whatever? It can be a really hard thing to struggle with. I mean, how do you
Yeah.
help people work through
I mean,
that?
I think it's really challenging because, like you're saying, it's complicated. There's a lot of really complicated emotions involved when somebody's in a relationship and they're feeling, like they're questioning safety concerns, and we really talk about the importance of emphasizing safety and the importance of emphasizing and even kind of zooming out from the relationship and
Yeah.
understanding, how important it is to keep safety as the number one factor. Um, and just making space to kind of process and validate how emotionally challenging that can be. So, I mean, I think it can be really helpful to have that therapeutic space to just explore and unpack and understand why that's just not an easy decision. I mean, sometimes somebody might be, outside of the relationship and saying to someone, why wouldn't you just leave, right? Or why wouldn't you get a protection?
Yeah.
Of course you should get a protection order. It's really obvious. Like, why do you feel bad for them? And why do you feel bad for the situation? But they're not in it, right? I mean, it is complex. There's a lot of different, I don't know, contrasting emotions at play that having space to be able to unpack and understand that as you walk through it and make that brave, courageous decision to prioritize your safety above everything else. I think having adequate support again is absolutely essential.
Huge. And it's really easy to be
Yeah.
like, well, obviously you should leave. Well, obviously you should get
Yeah.
that order. Well, obviously you should call the police. And it's
Right.
just not always that way when you're in it. But what I would say is if you're in a situation like that and you feel that you need help to leave or you are feeling really conflicted, it's really important to get resources. I mean, you can not just an attorney, like you should align with a therapist. There are DV resources, shelters. Every court has a DV advocate. If you go there, that will assist you. If you have to, when you appear in court, they will stand there between you and the other person, or if you're on Zoom, they will be there. So there's a lot of resources available, but it's just not always that easy. So Melissa, like
Mhm.
Melissa said, is right. You really have to work through these things. Um, One thing I didn't touch on earlier that I wanted to come back to is coercive control. I meant to define coercive control for you. We could really talk for an hour about coercive control, and I'm not going to do that, but it is a really important addition to our domestic violence protection order statute and defining what is DV in Washington state, as far as not just protection orders, but really, if you have a family law case, you need to know about it. So what is it? Well, coercive control is defined in RCW 7105010, subsection 4, if you are out there looking for it. And you could probably just put that in Google and find it. But what does it mean? It means a pattern of behavior. Okay, and this is really important, a pattern of behavior. It's not just one incident, it's a pattern of behavior that's intended to threaten, intimidate, humiliate, isolate, exploit, dominate, or otherwise control a person. Yes, that's right. It's intimidate, humiliate, isolate, exploit, dominate, or otherwise control a person that causes that person to suffer actual harm. And the harm you suffered needs to be physical, emotional, or psychological harm. So first, the elements: pattern of behavior intended to. Second part: threaten, intimidate, humiliate, isolate, exploit, dominate, or control. So you've got a pattern, this is what it's intended to do, and then you actually have to have caused that person to suffer emotional, psychological, or physical harm. So that can be a lot of things, and that's why I'm telling you about it, because it can be a lot of things. I mean, it's arguable that if you look at anyone's text messages with a partner at some point, you maybe have not been nice or have said things that have been kind of nasty. It's not just that, it's actual like threats or a pattern of behavior. So it's helpful to give some examples, and the statute lists examples. So I like to talk about them because we actually see them, and we've been seeing them for years, even before the definition, but they just didn't fit into DV. It was just kind of bad behavior. Well, now it is DV. So isolation: if you deprive a person with contact from their friends, relatives, or support system. Isolation is a really common thing. It's a real common thing. When a DV perpetrator will seek to isolate you with them and kind of be divisive and divide you between you and them, and it really seeks to isolate you. So that is a form of coercive control. Monitoring or regulating a person's movements, communications, finances, or daily activities. So if someone's monitoring you, why aren't you home? Monitoring what you're spending your money on, why are you spending money on that? Monitoring your communications with other people, monitoring your movements. That is a form of coercive control. And these are all forms of DV. Also, deprivation of basic needs. I see this one, unfortunately, more than you would think: controlling access to food, medicine, transportation, or money. So making somebody basically beg you for basic needs for money. You're the one that controls all the money, or they're the one that controls all the money, and you don't have access to that. Not giving someone their medication when they need it. That actually, unfortunately, happens too. Really being controlling about food or access to a vehicle or using things. So deprivation of basic needs is a real thing. And then there's the obvious one, which I think is obvious, but maybe isn't to everyone, which is threats or intimidation. Before, it used to be that if you were threatening someone, it kind of had to fall into the harassment category, or it had to fall into something like that. Now, threats or intimidation, threats to harm the person, threats to harm children, threats to harm pets or property are all included. So saying that you're going to do something to the family dog, threatening to harm somebody verbally, repeatedly, and a pattern of that kind of behavior, or threatening, this is a really big one too, unfortunately, threatening to or actually destroying property that's meaningful to someone. It doesn't even have to be valuable. Ripping up family photos or saying that you're going to do these things. Unfortunately, I've seen this happen before. I'm going to take your stuff to Goodwill, or I'm going to get rid of your stuff. And like that kind of stuff it's abusive behavior. And then reputation damage. This used to also only fall under harassment, but now it is domestic violence. Publishing or threatening to publish private information like text messages, communications, or intimate images too, like selfies, or things that maybe are not meant to be shared with everyone. So reputation damage is a real thing. And then economic abuse: controlling access to employment or financial resources. So that kind of is like restricting, that's a little different than restricting access to money. It's really like controlling, sometimes not allowing someone to work outside of the home, and really trying to be the one that controls the money, where they go, what they do. It's all kind of part of a bigger picture, but it's really important. And this is unfortunately very relevant now, but immigration related threats, using immigration status as leverage. If somebody is undocumented, it's not okay to threaten that you're going to report them or have them deported or anything like that, or have their kids deported if their kids are undocumented. That used to be just something that was whatever, and now that's domestic violence. It's coercive control. And also, in keeping with changes in the times, technology-based surveillance or harassment. So GPS tracking, monitoring devices, spyware, or digital stalking, using an air tag, anything like that. I had a case the other day where someone just said, well, he put a tracking device, put an air tag in my car, and tried to say it was okay because he also owns the car. Well, it's this person's daily driver. It's not okay. That is domestic violence. So it's really important that you recognize these things are not okay. And coercing participation in illegal or degrading acts, like saying you have to do this or I'm going to do that. And also using children or the legal system to harass or maintain control. So like had another case like this, repeated unfounded CPS filings, repeated police reports saying that you're doing things that you're clearly not doing, with no good faith basis. So all of those things are coercive control. That is all new as of 2023. And we do see coercive control protection orders. I was very skeptical at first because I was kind of like, well, anything could be coercive control. I mean,
Yeah, a lot
but at
could.
the same time, courts are really good about looking for specific patterns. I received a 3-year domestic violence protection order on behalf of one of my clients who absolutely was subject to coercive control. And it's made a huge difference in her life, being able to be free from that kind of behavior and having someone actually acknowledge that that behavior is DV, is not okay. DV is not just I hit you, I pushed you. DV is not just physical. And the recognition of that it's new for us. I say relatively new. Coercive control was added specifically back in 2021. And then when the statutes were consolidated later, it's modernized in all of our protection order statutes. It really wasn't before, even though it was defined. So it's important to talk about what was intended too, because I could say, oh, anything could be DV. Well, the legislature did intend like a broad protective interpretation reflecting the pattern and impact rather than individual incidents. If someone does something once, like that's not going to be enough. It's a pattern. Like if someone just says once, hey, I'm not going to give you this or that, like that's not it. But if it's a pattern of that, it's really about what the pattern is, what the harm is. Has this damaged you, in some way? Has this cut you off from your family and friends? It wasn't just one time, hey, I don't want you to go. It was every time. I feel awful when you're going. I might have to kill myself. All these kinds of things. That is DV, and that is what this statute is talking about. So a lot of this is confusing to people, and it doesn't get enough conversation, but I think it's important when you're seeking a domestic violence protection order, which again is kind of the landmark protection order and the one we talk about the most and the most commonly sought and received. Petitioners can rely on coercive control evidence. So that can be texts, Instagram messages, financial records, testimony about being monitored, followed. Your declaration is evidence. So you can rely on that. Respondents often will argue there's a lack of intent to control or there's no harm, but courts will often weigh what's the pattern and what's the context really heavily. Those are the more important things. And there is no requirement for physical violence. Emotional and psychological domination is enough and meets the threshold. So I really want to make sure that people understand what an important part of our protection order landscape this is. There's one other type of order I want to talk about, which is a restraining order. Before I do, anything you want me to answer?
We do have one question here. This participant's asking, they're saying they're just divorced and the opposing party bought their 13-year-old an iPhone and now we're being tracked by him through that phone. What can we do?
This becomes a real thing too. The whole like find my iPhone and location. And it's reasonable if you have the child with you to turn off location when the child is with you, if that person is using that. You can go into find my iPhone and turn off the location. And if they really have a problem with that, they need to trust that the child is safe while they're with the other parent. So
Mm.
if and like it works both ways. Like if you are on the receiving end, go in and turn it off. And if the other parent doesn't like it, well, then you might have to deal with it through counsel. But
Mhm.
there's no reasonable expectation that they need to know where the child is every moment when it's with you. And it could be a means of controlling you. Same way, if you're the parent that is giving the phone to somebody and wants location on the entire time, why? Why do you want it on? Why do you need to know? Are they with their mom or dad? Are they safe? Like that's enough. If they're going to take your child out of state, it's probably in your parenting plan that they need to give you notice, so you're going to know that. But otherwise, parent has a right to move around unimpeded with the child, and you don't get to know where that parent and child is every moment. So that's a great question because it's a very real thing. So anyway, excellent question. Anything else?
Somebody else is asking what court website shows the details of an upcoming restraining order before it is served? Is there one?
Hmm. That's interesting question. I'll tell you what, like if you're wondering, like, did somebody file this and I haven't been served, how could I know? I mean, you could go, and this kind of goes back to where something is filed. So, I mean, Washington courts, you can do a name search on there and it probably will come up. It's in Superior Court, um, or some district courts, but the courts maintain different filing systems. For example, King County is a different filing system than Pierce County or Snohomish County. So you
Yeah.
could go and you could check the filing system and see if there's a case filed. That's something that you could do. If it's in district court, like King County District Court uses CaseScript, which is a different system. You'd have to go look there. Municipal courts, like if you might need to look there, and that would probably be only part. In municipal court would probably be only if it was a companion and there was a criminal charge, and you would know about that. But so you can look in the specific court filing system and see if there's a docket that will show a temporary order generated that you haven't been served with yet. But there's not like one universal place that you can look for something like that. So I hope that's helpful. When I think about the restraining orders, it needs to be mentioned because we talked about protection orders. We talked about no contact orders. So what the heck is a restraining order? Everybody's like, well, I want a restraining order, right? Well, a restraining order is a civil order, and it is issued usually as a companion in a family law case. So for example, you can get a restraining order if something's not domestic violence, but you still have a reason to think this person should stay away. Or there can be a restraining order that's only about property. A restraining order doesn't fall into, the category of domestic violence protection order. It doesn't fall into the category of harassment. It might, you might be choosing not to pursue those orders, but basically, you have an open divorce case, let's say, or some kind of a family law action or any kind of a civil action, but let's just talk about family law because that's where it's most common. And you could then say, I want a restraining order issued under this case. You don't have to go open a new case. A protection order is a new case. A protection order can be consolidated with the family law case, but it's a new case. It's its own case. You don't have to have a family law action. You can't go get a restraining order unless it's attached to another action. So that's the difference. But a restraining order could be a financial one. When a financial case is filed, when a divorce case is filed, in most counties, King, Pierce, and Snohomish all issue what's called an automatic temporary financial restraining order. So that means that parties are somewhat limited by the way that they can use, transfer, borrow, or spend money during that time outside of the ordinary course of business. It's a financial order. It issues in every case. That's a restraint. That's a restraining order. It's a restraint. You will hear it. Other common types of orders, you could file a divorce case and be worried what's going to happen with the other party, and you could seek an immediate restraining order. Some people will call it an IRO or an immediate restraining order, and that might say pending full hearing, this person has to stay away from me. Or it might say if some kind of harm is going to occur, pending a full order, the kids stay with me. It's restraining the other party from having the kids until a full hearing. So restraining orders are used in the context usually of a family law case or other case. They're not criminal and they're not protection orders. They're civil orders that accompany a civil action or family law action. And you have to have those actions to get a restraining order. You can't just go down to the court and be like, I want a restraining order. They're going to be like, what's your case number? You already have to have one. So it's really important that you understand protection orders, no contact orders, restraining orders, all different animals, all available for different reasons at different times. So I hope that that's helpful to you. I would say this. If you are trying to decide what kind of order you need, maybe work backwards. Maybe think about what's the relief that I want? Do I want this person to stay away from me? That's usually what it is. Yes. Why? Then you can look at what their conduct was. Okay, is that DV or is it just I'm scared? Or maybe it's a restraining order situation. Did they commit a crime? Is the court going to issue a no contact order anyway? So think about what you want to achieve. Or is it a situation in a family law case where you have a reason to think this person's going to take the child out of the country, they're threatening to take them and leave or something like that, then that's a reason for a restraining order. That's not a protection order. So think about what you're trying to achieve and then kind of go backwards from there. A really good idea is to talk to an attorney about your specific situation. Even though you could get a protection order on your own, you only really get one shot at it. So you want to make sure that you're doing it right, because if you get denied, you can be stopped from seeking another order. And if you do try to seek another order without new things happening, it's what's called reapplication on the same facts. And you can't make reapplication on the same facts to the court once you've been denied. So it's very important to make sure to lay out exactly what happened, when it happened, why it's domestic violence, why it fits into the law, and what you're asking for. So that's like in a protection order context. Same thing with harassment. What is it? How does it fit into it? And here you go. If you are trying to claim coercive control, it's going to be important that you talk about the pattern, that you talk about the harm, and that you really lay it out there. Because here's the thing, the court is asking for you, this is our job as attorneys, it's asking for us to make it easy for them. It's asking for us to make it clear and help them make a decision. And if we can't make it clear, help them make a decision, then we probably don't have the evidence that we need, so we're probably not going to go ahead. So sometimes it can be confusing for a court if they aren't seeing the evidence and you know it's there, you just didn't know how to package it. They think that you don't have what you need to go forward, and they can't issue it unless they can find a way to make that happen. Same thing if you are, accused of something and someone's seeking a restraining order or protection order against you. You want to make sure that you are getting your side out there, because you have an opportunity to respond to these petitions and to say why, why it's not. And so it's important when you do that, that you are very careful with your pleadings. I will say this, restraining orders, protection orders, those are heard in court, and the paperwork that you file, the petition, the response to the petition, and the reply to that response are the most important things. They're far more important than when someone goes down to court and argues for 5 minutes, because you will get no more than 10 minutes, but typically 5 minutes to argue. And the court's not making a decision based on that argument. They're making a decision based on the paperwork that they received ahead of time that has to claim exactly what happened and why it fell into the statute. The oral argument, I always tell clients this, is often for show, for the clients. And sometimes it is for the court to ask follow-up clarifying questions. I'm not going to say it's not important, but courts would just assume, and very much can with the agreement sometimes in other kinds of matters. Here are things without oral argument. Oral argument usually doesn't make or break a protection order, unless testimony is being taken, which doesn't happen, unfortunately, that often. So it's good for you to know that that paperwork, my point is so important. And most of the time, 9 times out of 10, a judge or commissioner knows what they're going to do before they ever hear your case. I worked for a court in one of my first jobs, and it was the best thing I ever did. We would go, and my judges would have hearings on certain days a week. One day would be like protection orders, one day would be family law motions, and my job was to go through and make recommendations and prep everything ahead of time. They knew what they were going to do in every case. Maybe they had a few questions here or there, but they knew what they were going to do. That, because it's irresponsible for them not to be prepared and to make a decision based on 5 minutes of argument. So you really need to be careful, and you really need to plead the facts clearly. So if you hear somebody say you should talk to an attorney, it's not just because they want you to spend money or whatever. They want you to get the relief that you want. And a lot of times we have people come and it's too late because they've sought relief and they weren't able to get it. So I hope this was helpful to you. Melissa, do you have anything else to add?
I don't have anything else right now other than I do want to cue people into upcoming events
Upcoming
before we
events,
finish up the
yes.
call. There is our meetup group that we hold monthly via Zoom, quarterly in person, where we also have professional representation, mortgage professional, real estate professional. Myself and Michelle are also in that meetup where we talk a lot about the do's and don'ts of separation and divorce and various topics. So that's coming up. Our monthly event is on Wednesday, October 22nd at 5:30. And the next webinar is going to be on Thursday, November 6th at 1. And that's the final Divorce Foundation series of the year. And that's kind of where we talk a lot about all things divorce and separation and get lots of questions answered.
Absolutely. One thing for you to know too, like if you're new to our series or any of this, is that if you go to our website, you can link to our YouTube library. And that I've probably done several other protection order webinars over the years that you can watch. So there's a lot of things there. There's just a ton of content. And, the whole point of this series is really to provide information to you. It's not to make you be our client. I mean, some of you probably already are. It's not to, scare you or be like, oh, you need an attorney for this. It's really because this area of law, meaning domestic relations and family law, is very emotionally heavy. It's very confusing at times. And I strongly believe that part of what our responsibility is to make information accessible to you. So when I talk about things, I try to do it in a very real world, real person type way so you can understand what it means. And so it's great for you to go and watch content, watch other questions people have had, ask questions, and and really go from there. So I hope that helps.
Mhm.
And yeah.
Yeah, thank you so much for coming to the webinar today. Just posting here also contact slide in case you would like to reach out and get more specific questions answered or have a consultation, or if anyone's interested in counseling services, don't hesitate to reach out to me. And yeah, come to our future events because there's all kinds of webinars and great information. And the meetup groups are also full of a plethora of information. And sometimes there's questions being asked that you didn't think to ask yourself. So it's nice to be able to go and just absorb information.
Totally. And the last thing I'll say, which I think is important for people to hear, is that family court is really frustrating and it's really difficult. And so getting information and getting support is easy to do by reaching out and getting the information and the support, but it doesn't necessarily always mean that your process is going to be easy. And every situation is really different. So I encourage you to get all the support and information that you can. And, a lot of times these cases are marathons and not sprints. The real common thread is people want them to be over and they want the result that they want right away. And that does not always happen. And sometimes things happen that, we can't control, but we do the best we can. Every attorney does, and every person, I think, in the system for the most part does. A lot of people feel that the court's here to impact you in a negative way or to make your divorce really hard and not let you get across the finish line. And that's actually not really true. But it can be a complex situation to navigate. So getting access to resources and support is important. So anyway, thanks so much for coming. I hope you have a great day.
Thanks, everyone. We'll see you next time.